All right, we're going to finish out with information on the juvenile court trial process. So a trial in juvenile court is known as an adjudication hearing, and this is held to determine the merits of the petition. Adjudication hearings are comparable to an adult trial, and the case can be resolved in one of three ways. So a judge makes a finding of fact that a child or juvenile is not delinquent and is not in need of supervision. The judge can also make a finding that the child or the juvenile is delinquent and is in need of supervision. Or the judge can dismiss the case and just say there's insufficient evidence or faulty evidence. A delinquency finding is not the same thing as a criminal conviction. So constitutional rights that are required for these cases is basically about due process. And due process must be satisfied in juvenile court proceedings. So Galt, 1967 case, remains the key constitutional case in the juvenile justice system. It really reshaped the constitutional and philosophical nature of the juvenile court. It made it more similar to the adult system. In Re-Winship, the beyond a reasonable doubt standard of proof in juvenile delinquency adjudication hearings, which basically made it a level equal to the requirements in the adult system. So with disposition, this is the sentencing step of the juvenile court process. This is where the court orders treatments that are in the best interest of the child. Adjudication and disposition hearings are bifurcated, and dispositions have been based on the presumed needs of the child, and judges employ graduated sanctions for the juveniles. There is immediate sanctions, which is for nonviolent offenders, maybe community diversion or day treatment. There's also intermediate sanctions, and these are targeted for repeat minor offenders. And then, of course, secure care, which is reserved for repeat serious offenders and violent offenders as well. So probation is the disposition of choice, even in serious cases, and it really has grown in recent years. Most states and courts insist that the purpose must be rehabilitation and not punishment. So the practice has been to place children in the least detrimental alternative in order to foster the child's growth and development. Indeterminate sentencing is used traditionally in many states. Other states also have passed laws creating mandatory sentences for serious juvenile offenders. So there has been some sentencing reform. Some big cases that are important to talk about is in March of 2005, the Supreme Court in Roper v. Simmons put an end to the practice of death penalty for juveniles in the United States. The court ruled that the juvenile death penalty was in violation of the Eighth Amendment ban on cruel and unusual punishment. At least 366 juvenile offenders have been executed since 1642. Same thing has come true with another case file which talks about life without parole for juveniles. And Amnesty International and Human Rights Watch estimate that there are about 2,225 prisoners sentenced to life. About 356 of them were between the ages of 13 and 15 years old at the time they committed their crimes. It is estimated that just over 100 prisoners committed non-homicide crimes. Florida accounts for the overwhelming majority of these offenders. Granby, Florida, 2010, and that's the case that ended the practice of LWOPs for juveniles convicted of non-homicide crimes. So juvenile courts normally restrict appeals to cases where the juvenile seeks review of a final order or one that ends litigation. The appellate process gives the juvenile the opportunity to have the case brought before a reviewing court. Appellate review of a juvenile case is a matter of statutory right in each jurisdiction. The majority of states do provide some method of statutory appeal. So, confidentiality must happen in juvenile proceedings. Habeas corpus refers to a procedure for determining the validity of a person's custody. It is used to challenge the custody of a child in detention or in an institution. Much attention in recent years, open versus closed hearings, privacy of the juvenile records, have become a thing. Many legislators have broadened access to juvenile records, and Supreme Court claimed that the juvenile's interest in confidentiality was secondary to the constitutional right to confront adverse witnesses. There's extensive privacy that happens with juvenile records. They can only be opened in court orders, and there is certain agencies that can gain access to those records, and those are usually with a search warrant or a subpoena. So what is the future of the juvenile court? Over the years, the juvenile court has taken on more characteristics of the adult courts. Treatment programs provided by the modern juvenile court play a central role in society's response to the most serious delinquents. Juvenile courts must ensure that these programs are indeed effective, and this includes awareness of up-to-date scientific evidence, knowing about diversion of cases, also disposition of cases to appropriate programs, and it serves as a quality control method. Juvenile court needs to be guided by a core set of rational and science-based principles, such as systematic assessments of culpability and treatment needs, and a consistent balancing of punishment and treatment. That wraps up this chapter. Have a great night.